I'm going to call the meeting of the House Motor Vehicles Committee to order, and I'm going to ask Representative Harden, would you just lead us a word of prayer to start off with today? I'll give you a number.
Lord, we thank you for this opportunity to come down here and do the work of the people of Georgia. And Lord, we just ask for your wisdom and guidance, not only in all of our work, but this committee here. And Lord, let your presence be known. Be with us as we travel home for the weekend. Keep us safe and bring us back. Lord, we thank you for everyone that's going to present here today and ask you to be with our families while we're here. In Jesus' name we pray. Amen.
Amen. Okay, thank you, Representative Harden. There were two bills that were on the agenda today, House Bill 113 and 114. And I've added House Bill 279 to that list for today. We're going to hear 113. It's Chairman's intention to move on 114 and to move on 279. So listen attentively, and we will go ahead and start the consideration of these bills. And it's an interesting set of bills because the sponsor is all the same name, and it's kind of interesting just to move one to the next and have the same gentleman sponsoring it. So, Mr. Powell, why don't you tell us about? Let's start with 114. Let's move on that one first.
114.
Let's do 114. Got a numerous 20.
Thank you, Mr. Chairman. A couple of the bills, 113 and 114 today, deal with the towing industry, towing and storage industry. 114. Was of key importance to a lot of those operators, especially in the metro areas, when they are required to tow vehicles. The non-consensual towing, they have to file affidavits if that vehicle has been abandoned. It was a $10 filing fee, and over the last few years, this has been, or the last year, I think, more particularly, there's been a lot of add-ons that's been made to this, and this clarifies that basically no additional money shall be added to the cost of the filing of this affidavit.
All right. Questions for Mr. Powell on House Bill 114? Any questions? I have a question.
Yes, sir.
What parties are adding fees to the bill currently, to the affidavit currently?
I'm sorry. I didn't understand.
No, who is adding the fees now?
Well, a lot. Quite honestly, this situation seems to be more of an issue in the larger metropolitan areas where they have a lot more non-consensual towing of abandoned vehicles and such. So, generally, this falls into the place in the more metro areas. But originally, we had a $10 filing fee, and there's been other fees, as we know, that depending on jurisdictions that you go to, a lot of them do things different, and a lot of them have been adding fees. Fulton County, for example, has been adding a good many add-on fees to it, $20, $30, $50 in some cases. And so this is not a, this is not a standardized practice around the state.
Do you have any reason why Fulton County would add that fee except to make a little money on the revenue standpoint?
I think it's a 6-letter word called Fulton. No offense, but that's quite honest.
Is anybody here from Fulton County to rebut that? No. All right. Is there discussion on the bill? Sure. Representative Holcomb.
Thank you, Mr. Chairman. Just one quick question. How long has the fee been $10?
Probably since the beginning of time, but it's just a traditional a standard filing fee as an affidavit that a vehicle's been abandoned. I've been here 22 years, and I guess it's been that longer since way before I was ever here. Okay. Quite frankly, this clarifies. This is just clarification. It says that it's a $10 filing fee. In the statutes right now, it says that. But last year, as I understand, upon doing some investigations, that last year there was a lot of misinformation in a certain bill that was passed, a fee increase bill last year, that allowed other fees to be added on. Now, the statute that deals with this is quite clear. It says $10. Some of the jurisdictions last year, they took it to believe that legislation that allowed add-ons would, since it was the last passed, would add to it. And it was, while this fee particularly was never mentioned as an increase in fees. And I think that for the benefit of what do we have? Just you're the freshman on the committee for your information on this, and we'll get into it maybe a little bit more in the next bill. We have a situation that is quite an anomaly. We have businesses in the towing industry, in non-consensual towing especially, where they're called on by law enforcement to pick up abandoned vehicles and such. In most of the cases, when they pick these vehicles up, they're derelicts. They wind up going to the salvage yards. No one comes to claim them. So the only way that they can clear their yard, they have to file an affidavit of an abandoned vehicle and then a prescribed course of how to dispose of those vehicles. So in a lot of cases, they're paying, in this case, $10, and then if there's an add-on of, $50 more, in most cases, they're not going to get the money back out of the vehicle that's been sitting on the impound yard.
Okay, thank you.
Any other questions of the author from the members of the committee? Ms. Porter, would you care to comment on this bill from the standpoint of the industry? Come on up. I don't see a microphone. Yeah, you have to go over there because it's on the web.
Hi, I'm Paige Porter with ATO Atlanta and downtown Atlanta, and also representative of the Towing Association. And the way Representative Powell described it is exactly point on, and TRAG supports it, and us as an individual towing company, we support it as well.
How much add-on fees have you experienced?
Fulton County is $41.50, so $31.50 additional. Each county seems to be different. Some don't add on, and some I've heard up to as high as $55.
Okay. Was there any justification for that in terms of processing of the affidavit or not?
Well,
Probably
I don't
not.
think so, because I mean we've processed tens of thousands of cars over the last several years, and in 3 years we've had one hearing. So it's a lot of add-ons for something that's not necessary, something
Okay.
that hearings aren't necessary.
All right, any questions of Ms. Porter? Okay. Is there a motion on the bill? Thank you, Ms. Porter.
Mr. Chairman, make a motion to pass
On House Bill
on House Bill 114.
Is there a second? Second. All in favor say aye.
Aye.
Aye. None opposed? Thank you, Mr. Powell. Bill 114 passes. I think you want to do 279 and get it out of the way. Just move on to 113. Up to your choice.
Well, while I'm on the roll, I explained that pretty good, didn't I?
You did pretty good. Pretty good. Yeah. All right. I'm going to call House Bill 113, and same topic area. Ms. Porter, you might as well be ready to come back up the microphone and testify again on this. Mr. Powell.
Thank you, Mr. Chairman. Since I did so good, I'm not quite sure how I explained that first one so clear. If I didn't know any better, that's where I had been around this committee a while.
Well, I'm sure you'll do very well on the House floor explaining the same thing.
House Bill 113 also deals with the abandoned motor vehicles, and this deals with changing the definitions of the contents of those vehicles. When a vehicle is towed in, it's basically towed in, and those people they have to be paid for their services if that vehicle is claimed. And this bill has been before us, I think, several times in the past, and for whatever reason it didn't move forward. But this basically sets forth the contents that have to be left in that vehicle. And when I say the contents, a lot of times contents, that's the reason somebody will come back to pay that storage charge, especially if it's a derelict vehicle. And what this does, it basically says that the facility that tows or transports, that they'll have that lien on the vehicle for the first 30 days of the storage, and then those things that need to be given back. And that's laid out here, the prescription drugs or eyewear, medical devices, which I'm not quite sure what that is, but it sounds pretty good, child restraining devices, keys, except the keys to the vehicle, and personal documentation such as birth certificates, passports, or death records. Basically, those things of a more personal nature that they might need to do whatever they're going to do with. And that's what this does. It sets forth those exemptions, give those back. Currently, you have some operators in some parts of the state, when they tow a vehicle in, they basically lock it down, and the owner of that vehicle can't get to any of their personal property. but given the drugs and the, restraining and medical devices, it's easy to understand. It's sort of a consumer, I guess you could call that really a consumer-friendly piece of legislation for those folks. And there has been a proposal for an amendment from some of our other friends on this, and at the proper time I'll go into that.
We're not going to, I think we can discuss the amendment as far as the hearing goes. We're just going to hear this bill. We'll vote on this bill next week at the next meeting. You want to talk about the amendment, the proposed amendment right now?
Be glad to.
Why don't you do that?
Some of our friends with the automobile industry, they would like to put an amendment in there that states, in the case of a repair facility that has stored a vehicle which is or becomes abandoned, such lien shall also include the reasonable cost of the repairs.
Is that it?
That's it.
Okay. All right, any question for the author? Committee members? Mr. Holcomb. Oops.
Representative Powell, can you just explain to me, I'm reading the second sentence of subparagraph D1, and it states
Which line would that be?
the amount of this lien is limited to the reasonable towing and storage fees plus the costs of notification to the vehicle's owner where applicable. Why would it be where applicable for the notification? Should that be a mandatory notice?
I guess that's legalese that the attorney wrote in there.
You want to comment on that, Mr. Ruskell, number? 13. Mr. Ruskell.
That actually is a good question. I would think in most situations, certainly in the non-consensual towing situation, notice would be mandatory. And I'm struggling coming up with a situation where it would not be mandatory. There may be somebody in the audience, Mr. Chairman, who could help us with that. If not, I agree with Representative Holcomb that we should take out the where applicable.
Okay. All right. Thank you, Mr. Holcomb. Appreciate you catching that.
Thank you, sir.
Are there any other questions for the author or members of the committee? Mr. Johnson, you look like you got a question down there. You got a question? You fine? Okay. All right. Thank you. Well, we don't have a motion today. It's a hearing on this one, Mr. Johnson, so we'll move on that next week. And the purpose of this is because this is a sensitive topic for a lot of people. I want to make sure everybody gets a chance to be heard, and we'll reconvene on it next week and vote on it. I'm going to ask Ms. Porter to come back to the microphone and comment on this. Tell us more about the 30 days and why that is the key date, and how these vehicle content exceptions were put in place. What's the basis for them?
The 30 days is primarily as once it's been there 30 days and it kicks into the abandoned motor vehicle law, so that kind of takes over the rest of the process. But in most cases, the vehicles, when they're towed, either if they're for a police agency, then at the time, if it's an accident, if everybody's well and okay from the accident, they have opportunity at that moment to get whatever personal items out. If there's any personal items that the police department that they need to take in possession, then they have the opportunity to get those items as well. It's not known that the police department would take out glasses or car seats or things like that. So if a citizen came back or a vehicle owner came back for something of quality of life issue, then we certainly want them to be able to get those items. If it's a vehicle that was parked at the mall or at a restaurant or something like that, a private property impound, then more than likely those type of people are going to be coming to retrieve their vehicle anyway, so contents aren't really an issue. So again, we think quality of life items, we need to make sure that everybody abides by that they understand that, but also too that it's known that they do have opportunity to get those items before they go into impound.
Okay. I have a follow-up question, but are there other members of the committee that have questions of the witness? Maybe it's another couple of questions that I've heard about. And question has to do with the statistics that support this. and the number of times that a car goes over 30 days, and you do want to exercise a lien opportunity on it. What percentage of the cars, and what would be an actual number for your business?
The percentage for us is about 10% over a year's period, and at that point, you know, the vehicle is abandoned, the contents are abandoned, everything is in the abandonment of vehicle law, so therefore it would be, we'd proceed to auction.
Okay.
From those fees, we get probably about 30 cents on the dollar.
Okay. And the 10% represents in actuality how many vehicles do you
Probably
think?
about 6,500 a year.
6,500 vehicles?
Yes, sir.
Okay. That people don't come back for?
Yes, sir. Well, they, I don't know if you saw in the news a couple weeks ago during the ice storm, but they actually did, CBS did a story where they came to our auction, and if you saw those vehicles, you'll see why people wouldn't come back. They are truly abandoned.
The other question that may shed a little more light for committee members would be the financial comments you made about 30 cents on the dollar. Why don't you explain just for a second how the storage charges work, what they mount up to over a 30-day period of time, and what you're actually able to recover on average on these cars that are you put a lien on?
Okay. As soon as we retrieve or impound a vehicle and it is located on our lot, we have to go through a notification process. So I certainly agree with the earlier statement. Where applicable is mandatory already. So I mean, I think I agree with that. But we have to, within 3 days, we have to get owner information for those that are registered to the vehicle. We have to notify them to let them know where their vehicle is, how much it cost, and what the process is to come retrieve it. After 23 more days, then we can go to the state of Georgia and we can request additional owner information so that we make sure that we have vehicle owners, financial lien holders, or anybody else that may be associated with that vehicle. So then we go through the process of second notification to let them know. And all the time, the vehicle is building up storage, and we have to be responsible for the safety and security of that vehicle. And after 23 days, then on that 7th day, then we can go into the abandonment of vehicle portion of the law. And at that point, we can file for a affidavit for foreclosure. So when we do that, that comes into the court fee, so you pay whatever the appropriate fee is for that. And then 10 more days go by, and then you pay for advertising fees before you can go to a public auction. Once you've gone to get to the point of a public auction, typically you have an average of $1,000 to $1,200 in the vehicle and towing and storage fees. You cannot, once you foreclose on that car, you can't accept anything higher than that if it goes to auction. So if that car is auction, or say for easy numbers, if it's a foreclosure of $1,000, if the car sells for $500, then we've lost 50%. If it sells for $2,000, then that additional $1,000 goes back to the general fund of the state. So at best, we can break even. Most times we don't, so that comes back to the 30 cents on the dollar.
And so, as some have said to me, if there's a set of, and I'm not going to be able to quote this correctly, but if there's a set of golf clubs like Mr. Morey would probably have in his car, that were probably worth more than the car itself, how would that work in that? You're still only able to collect up to
The foreclosed fee.
the foreclosed fee.
That's correct.
Okay. And the rest goes to the state.
That's correct.
So, Mr. Morey, if you have a car that's towed and you don't pick it up in 30 days, the state's going to make some money on your golf clubs. I think it's probably what Are there any other questions for Ms. Porter? She's obviously well informed on this subject, and we thank you for. Oh, I'm sorry, Mr. Ruskell, you want to ask a question?
While you're here, I just thought of a where applicable situation, and it's worth discussing. While you're up here, you would certainly know more about it than I do. If in the situation where a car is towed non-consensually, but the person becomes aware of it and follows you to the lot, which I assume can happen, then there would not be any necessary notification, I assume, and so there wouldn't be any notification costs in that case. I don't know if that's rare, would never happen, or does occasionally happen, and that might be a situation that would be addressed, that the person follows this car to the towing facility and tries to arrange to pick it up right then. If you could comment on that, I would appreciate it.
I'm not exactly sure would they be following from like where they were at an accident, or what?
Or somebody calls them and says the police are towing your car. You better get down here, and it's already on the record, and they follow you, and they follow the record to the facility, something like that.
If that car was, even though they followed us and they left it there, we would still be bound under the same laws and
Okay.
the same rules that we would have to go through the notification process.
Okay.
If it was at an accident, which happens, and that person doesn't know where they want to take their vehicle yet, so they have to get in touch with their insurance company or whatever, they may say, why don't you just take it to your lot and then we'll make a decision later. We consider that a private tow because they've given us the consent to tow it to that location.
Okay. Thank you.
So would council agree that that's not?
I would agree
so
then that that's not necessary to have those in there, those words in there, yeah.
Thank you. There's another question here from Representative Battle.
Thank you, Mr. Chairman. It brought up an interesting point as to contents in vehicles that have been abandoned, and you're towing those in. Do you do an inventory of what items are in the vehicle, and then after, if that is done, is that turned over to law enforcement, or is that who knows what has actually been in that vehicle?
That varies from probably company to company and jurisdiction to jurisdiction. I know as far as when we tow for a police agency, that police agency example for Atlanta Police Department, if they were to have a car impounded and there was something of value over $25, in their contractual agreement with us is that they will take that property and they will take it to a location where the citizen has to go get a release from them, and at that point they can retrieve any of those items. As just a business practice, we do take note of everything in the car. We don't go in the cars, but if you visually note that there's something in that car, then that driver would indicate that on his invoice. So if somebody had a situation where they said they had, a laptop in the middle of the seat, and then 2 days later they came back and it was gone, then they obviously would have to have their protective rights as far as the contents are concerned. But as far as going through the vehicle and removing anything from it as far as an inventory sense, no, we don't do anything like that, but we do indicate it.
What I was thinking of is not necessarily golf clubs, but I was thinking about weapons, guns that may be in that. How do you care for the items that might bring some harm to someone if it falls into the wrong hands? And
as far as, again, going back to the police agency situation, then if there was a firearm, the officer does go through the car and he would remove those items.
So he does.
So if it was $25 of value or firearms or illegal substances or anything like that, all that would be removed. If it was, again, the scenario from a private property impound, and it was at Lenox Square or whatever, then we do not go in the car. If we visually saw something in the middle of the seat, then we would notify local law enforcement. If it's concealed or somewhere that's not seen, then we don't know that it's there or not, but it's more of a liability for us to go in the vehicle to go search the car instead of just not going in it at all.
Okay, I have one other question. If that process ends up going up to the 30 days, and you file to that car as abandoned, and then it is auctioned off, those contents are still in that vehicle, right?
That's correct. However it came is however it goes. So if there may be somebody that went to the auction to buy a car and he bought it because of the golf clubs, because the car wasn't worth anything, but whatever it came with is what it goes with.
I'm more concerned about whether or not there's a weapon in there than I am about. I want to protect your golf clubs, but if there happened to be a weapon in there, that's a danger.
That's typically not a business practice, but I do understand that concern.
Thank you.
Any other questions? Sure, Mr. Chairman Harden.
Just inquiry for you. We will be discussing this, particularly the proposed amendment, before we make any action on it next time.
Yeah, there have been other committee members who are not here right now that expressed some concern about it. I want to make sure they get heard on it.
Good, thank you.
Okay. Any other questions for the witness? Ms. Porter, thank you so much for coming. Mr. Powell, do you have any final words you'd like to say on this?
No, I just say kudos to the to our newest member of the committee. All these years, lawyers have always been able to explain why they put certain verbiage in there, I've never been able to trap them. They could always explain that. So, good man.
And Mr. Powell, this would best be handled, I think, on the amendments and the changes by committee substitute. If you have that prepared, that would be great for the next time we get together. Okay, we're going to suspend any action on that bill, and we're going to move to House Bill 279, which is also Mr. Powell's bill.
Mr. Chairman, and this is, quite frankly, this is a bill that normally was not in my earlier repertoire as a younger legislator. Used to call these nanny state type bills, but as it became over a period of years, as I became softer and gentler.
Not sure when that happened, Mr. Powell.
But as I became of a certain age, I realized there was legislation that was appropriate for children and old folks. And I guess it's because I became an old folk up here. Back several years ago, we passed legislation dealing with child restraint systems. At that time, we specified under the law that children under the age of 6 years old would be properly restrained in vehicles. The language in the current law did certain exemptions, or as I remember saying something about fat babies and stuff like that that couldn't get into child restraint. And those exemptions are still into the code. Mr. Hawkins, as you read the bill, the exemptions are that children that weigh at least 40 pounds, they're exempted from those certain child restraint devices. Our friends at Children's Health Care have come forward, and they see that there's a need that we apparently have a lot of children today that are over the age of 6 years old, that when their mamas and daddies strap them into a vehicle, that seat belts and shoulder harnesses can create a hazard to them if they're not of a certain height and a certain weight. And what they've asked us to do is to change this language from 6 to 8. And I will remind the committee that all the fines remain the same. There's no changing in the fines. And quite frankly, it just raises the age from 6 to 8. Exemptions remain the same. Did a little clarification of law, changing public safety to driver services where the point system would be applied. I do, as I was looking through it, and I think maybe the folks at Children's Health Care, Mike, can help me. I did have a question on line 38, which we gave it a split, changing the age from 5 to 6 or 7 while we went to that. So that would be the only question that I would have as I'm looking at this bill. But at this time, it would be the chair if he would call the folks from Children's Health Care to plead their case.
Okay. Thank you. We'll have, I think, Jamila, I think you're the only one signed up to speak on this bill. You'll come up to the microphone over there. I'd appreciate it, and you comment on the bill.
Mr. Chairman, members of the committee, thanks, Representative Powell, for bringing this forward. And
this is Jamila Pope from Children's Health Care.
Yes, thank you. And on behalf of Children's and Safe Kids of Georgia, we are in support of this bill. And Representative Powell, about your question on line 38, that is just an exemption. That's a first offense waiver that says up until January 1 of 2012 that if a parent was or someone were to get a ticket for such a violation, if they can prove that they have purchased the correct device to restrain the child going forward, I guess that can be waived.
Mr. Powell.
I might ask a question that caught my attention, that we have changed 5 to 6 or 7. Would we not put a specific age?
Well, the reason why it's 6 or 7 is because those are the new children that will be covered under this change. Right now, I guess we shouldn't exempt someone that's 5 or 4 because they were already being required. So this is just pertaining to, this is a change in the law. So we're going to give them this period to, I guess,
carry over a couple of years.
And the folks from the Governor's Office of Highway Safety couldn't be here today, but they did want me to say they are in support of this bill.
Okay. There are some other questions. I'm not sure who came up first. Mr. Johnson, we'll give you an opportunity to ask a question of either Ms. Pope or Mr. Powell.
Thank you, Mr. Chairman. Wanted wanted to ask, and this is really for my education, but how are parents made aware of this? Is it posted on the seat at the time of sale, or is it?
Well, typically in the past, when we have changed child passenger safety restraint laws in Georgia, the Governor's Office of Highway Safety has been active in educating the public. They have lots of information on their website, and they have various other ways of getting information out into the community so that parents are made aware.
Good.
All right, Mr. Johnson. Is that your question? Okay.
And if I may add to that, there's language in the law, if I can find it, under the fine statutes up here that would give the court, if someone is stopped and didn't know about it, it would give the court the jurisdiction to waive that fine on the first offense if they have in fact bought that prescribed child restraint seat before their court appearance.
That's lines 41 and 42.
Mm-hmm. Mr. Harden? Wait. Okay. Okay. Mr. Holcomb?
Thank you, Mr. Chairman. As a practical matter, will there be much of a difference between the seats that parents are using right now if we change this law from 6 to 8, or will most of the seats that are being used or booster seats be the same ones that parents can just continue to use?
Well, really, I don't think changing the law is going to really be the issue there, because each child is different. The size, the height, the weight of each child is going to be different. So you may have a child that needs a larger booster seat at age 5, and that, another child may be in a smaller booster seat at age 7. So it's just really going to be an individual thing with each child.
And the weight exemption would apply to that also, right?
Yeah, we're not that bill doesn't change anything regarding the weight.
Mr. Holcomb, you all right?
Yes, thanks, sir.
Okay. Mr. Harden?
This question, I'm sorry, I'm in support of this, but question probably better suited for the chairman. Being a sophomore, why is it that this is more toward the age rather than a specific size, like a height? I mean, what's the rationale in the past been to tying it to an age where you could have a 6-year-old that's clearly tall and an 8 or 9-year-old that's clearly shorter? Can anyone shine light on why we do it by age?
Ms. Pope, why don't you answer
Okay,
that?
great.
The reason why is that this is more about a child's height than a child's weight. Because what the booster seat does, which is the child restraint system that would be applicable to children ages 6 and 7, is it actually raises them up. A seat belt is made for an adult-sized body. So when you put a seat belt on a child, they can sustain severe injuries. What that booster seat does is just raises them up so that the belt fits properly across the abdomen and the chest. That's why it's more of a height issue, not so much with the weight. Yeah, and
David, you want to comment on that?
Sorry,
Introduce
David
yourself.
Tatum with Children's Health Care of Atlanta, and I was the one that helped get the original bill in 1998 passed that raised the car seat booster seat age
Been
from
that
2
long.
to 4.
Wow.
And then about 6-7 years ago, Mr. Powell was kind enough to carry the bill that took it up to the age of 6. The reason we went with the age instead of the height and the weight is law enforcement's testified in, I think, this committee before, that they don't carry a tape measure around to measure how tall a child is or a scale. But when a man in uniform or woman in uniform asks the child how old they are, they'll say, I'm 5, I'm 6, I'm 8. And they find that to be a better enforcement mechanism than actually getting the child out and measuring their height or trying to weigh them. And again, there is a provision in here that if the folks buy a seat, if they get stopped, they've got a period of time to do that, and there's a grace period involved in this. And again, all this does is raise the age to the age of 8. That complies with the federal guidelines. I ran into Mr. Dozier, the the Commissioner of Department of Driver Services down here a couple of days ago. He said the governor's office had asked about it. They're in compliance with NHTSA if we do this. Several other states have already done it, including Kentucky. And back to the governor's office, I believe Jamila, the First Lady, has already indicated she's going to get certified as a car seat installation technician this year.
Like
I hope that answers your question.
It does. Thank you.
Okay. Mr. Battle, do you have a question?
I was just going to, I'd asked the question yesterday, I believe, or day before yesterday, of my concern about whether or not the weight or the age being changed from 6 to 8 was a controlling factor here, and you spoke to that. But if a child is at least 4'9", whether or not there's an officer who is able to measure that, they would not be cited for, would they have to go back and prove that that child is above 4'9"? Does this create a problem?
I wouldn't say it creates a problem. Current code says that if the child is over 4'9", they are exempt. Again, that's not being changed in this bill. So I guess if a law enforcement officer were to give a ticket, I mean, the judge wanted to measure the child, I guess they could when they went in, but it doesn't change anything that isn't already just set forth in current code.
Just a little aggravation to a parent if they're
and I, through the other organizations in the state, I certainly haven't heard that that is something that is being a problem for parents right now.
Oh, I support the bill, but that was a question that if a child at 6 years old is 4'9", they've had a growth spurt, then they're exempt, right?
They are exempt if they're over 4'9", yes.
Okay. All right, thank you.
Mr. Holcomb.
Thank you, Mr. Chairman. I have on my computer a list of all the different states and what they have, and it definitely looks like the trend is more towards the 8 years, but it looks like the weight that we have of 40 would be well below what most other states have. So should we move that? The age of 57 months is consistent with what most other states are, but I'm a little bit concerned that we might be below the threshold on the weight. Can you address that?
Well, the National Highway Traffic Safety Administration does recommend that if that a child be exempt if the child is over 4'9" and if the child is, I think, at least 80 pounds. So Georgia's law is not in line with the 80 pounds recommended by NHTSA, but that has been just what has been, I guess, comfortable for folks here in Georgia in the past, the 40 pounds. And that 40 pounds, that exemption in current code is only applicable if the other lap and shoulder belts in the vehicle are being used to restrain other children. So it's not just, if the child's over 40 pounds. So we're restraining the children if we can, if there are seats and lap and shoulder belts available.
David, you want to comment on it?
No, the issue is not that they're exempt over 40 pounds. It's that if they are 40 pounds and there's no other space for them to be in certain circumstances, I think if you look at lines 19 to 23, then there are the ability to have the child ride in the vehicle restrained only by a lap and shoulder belt. But generally speaking, the height is the consideration that would allow them to be exempt from this.
Having to do with where the shoulder, where the seat belt would normally come down over.
The booster seat lifts them up so that the lap, sorry, I'm going to get a horn in. The lap and the shoulder belt hit them the right place, because if they're sitting too low and just restrained in a lap and shoulder belt, if they're in an accident, they can either slip out of the belt and they'll go through the windshield like a missile, or they fold up like an accordion. It does serious damage to their internal organs. And the Academy of Pediatrics nationally has recommended that it go up to the age of 8, and that's a standard other states have applied, and we just want to bring Georgia in line.
Any other questions? I have a question, and that has to do with the data that Mr. Hochet presented from the Pediatrics Academy, I guess. Do you care to comment on the number of accidents or the number of injuries, that fatalities or injuries that have been ascribed to the problem of our booster seat law?
Governor's Office of Highway Safety would probably be best to go over those, but since they're not here, I do have that. What I do have is that from 2004 to 2009, there were 263 children in Georgia, ages 0 to 9, that were killed in motor vehicle crashes. As far as the number of children, I don't have any of the statistics with me regarding how many were restrained versus not restrained.
Okay. I think Mr. Shea had some other data on that, as I remember his email to me, but that's
I have it,
fine.
yeah.
David, you want to comment on that also? See you stand up. I'm either going to leave or you're going to comment.
It's hard for me to back away from this because I've lived it and breathed it.
Sure.
He sure has.
He has. Are there any questions on the bill or of the witnesses? Any discussion? Hearing none, is there a motion on the bill? Is there a motion on the bill?
Yes. Mr. Chairman, I move that House Bill 279 do pass.
Okay. All right. Is there a second? Okay, there's a second, Mr. Harden. Okay, well, let's take a vote on it and see what the pleasure of the committee is. All in favor of passage of House Bill 279, say aye.
Aye.
Opposed? Okay, we're done.
Thank you.
Thank you all for coming. There's a number of bills coming up that have been assigned to motor vehicles over the course of the next week. We'll pick up on those next week, and we'll pick up on the House Bill, I guess it's 113 next week. Thank you all for coming. Have a great day.